Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I'm excited to be moderating today's webinar on communication caps and call frequency limits as part of our series, Dissecting and Analyzing the Debt Collection Rule from the Consumer Financial Protection Bureau. As was expected, the CFPB included in its debt collection rule a limit on the number of communications and communication attempts that can be made when collecting debts. Today in this webinar, which is part of a series, like I said, on the debt collection rule being sponsored by TCN, we have a panel of experts from across the accounts receivable management industry who are here to share their perspectives on this provision of the rule and its likely impact on collection and contact rates. This is the second in a series of webinars aimed at helping the industry better understand the debt collection rule and how to apply it to your operations. Before I introduce the panel, I want to take a quick second and say a few words about accountsrecovery.net. Accountsrecovery.net is a news and information platform for the ARM industry. The site publishes unique and curated content, maintains a number of email newsletters, hosts webinars like this one, offers a number of exciting podcasts, and manages a Slack channel, all for the ARM industry. All that great content is free for everybody to use, and I happen to think it's a great resource of news and insights to help educate and inform. I hope you all spend a few minutes every day checking out what it has to offer. Now, let me tell you a little bit about today's panelists. LaDonna Bowling is the Chief Compliance Officer with Receivable Solutions. She has more than 20 years of operational and compliance experience in third-party debt collections, experience in all verticals, serving creditors and debt buyers. LaDonna is a certified instructor with ACA International and was named one of the 25 most influential women in collections by Collection Advisor in 2016. She was also named ACA International Certified Instructor of the Year in 2019. Rick Purr is the co-managing partner of the Philadelphia office of the law firm of Kaufman, Dolowich, and Valuch. He also chairs the firm's National Consumer Financial Services Practices Group. He's a nationally recognized authority and lecturer on creditors' rights, representing creditors, law firms, and agencies against individual and class action allegations, invoking federal and state consumer protection laws, including the FDCPA, the FCRA, and the TCPA. Rick is a past president of ACA International and currently sits on its board of directors. Lauren Valenzuela is compliance counsel at Performant Recovery Incorporated, where she advises on compliance with consumer protection laws, government regulation, licensing, litigation defense, and transactional matters. Prior to joining Performant, Lauren was general counsel and director of compliance at Collection Technology, Inc. The format for today's webinar is going to be a panel discussion. We encourage everybody to submit questions, and we'll get to them as our discussion is ongoing. To submit a question, please either enter it into the Q&A tab or the chat module on your Zoom webinar control panel. This event is being recorded, and a recording will be made available in the coming days on accountsrecovery.net. Finally, since we're going to be talking about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area and should never be used to replace the advice of your own legal counsel. All right, panel, now that you've all been indemnified, let me bring you on and welcome you for our conversation today. Let's start with the easiest discussion. Let's talk about what the CFPB has proposed as it pertains to how many times a collector can attempt to contact an individual and how often they may actually speak to that individual. LaDonna, since you were the first person to join our webinar today, I'm going to let you go first.
Thank you so much, Mike. So what was the question again?
I forget.
Well, as far as all the rules go, I thought this one was pretty simple, 7 times in a 7-day period. And then from hanging out with lawyers, I go, it depends on what happens next. Right, Rick?
Absolutely. There's always an it depends. Well, look, first, before we even get into it, we had the breaking news today that the rule was actually published in the Federal Register. So for everyone that's aware, there is a one year countdown to when it goes into effect, 1 year from the date of its publication. So November 30th, 2020 goes into effect November 30th, 2021. So the clock is officially ticking on implementation of the rule, barring a few little fun things that may or may not happen over the course of the next year. But LaDonna has it pretty much right, which is there's a two component part to the rule when it comes to call caps. It is you may make 7 telephone calls within, and mind you that these caps are a presumption of legality, although the presumption is rebuttable depending upon the facts, and I'm sure we'll talk about it at length here during the course of the hour. But you can make 7 calls to a consumer per account within a 7-day period, assuming that you do not connect with that person. Connecting meaning talking to someone live. And if you happen to get a hold of somebody and actually speak to the consumer within that 7-day period, at that point, you cannot make a second call back to that person following the contact unless you're given permission within that next 7-day period of time. So the example is, I start making calls on a Monday. I don't get anybody till a Thursday. On Thursday, I reach somebody. I talk to them. Unless I get consent to speak to them earlier, I can't talk to them again until next Thursday. And so it's the 7 and 7 rule. And it applies per account, not per consumer. So if you are collecting 5 accounts, you technically could reach out to somebody 7 times for each of those 5 accounts. And if you make a contact, that counts as to the contact, the account that you'd be talking about. Although that runs into some issues of record keeping and otherwise that I'm sure Lauren and LaDonna will fill us in on how their businesses plan to do it. But that's the gist of the 7 and 7 rule on call contacts.
And you made a point to be specific about the accounts, and it's not phone numbers. So if I'm calling Rick Purr and I have 4 phone numbers, if I call all 4 phone numbers today, then I've used 4 of my 7, right?
That's right.
Now, the rule does specify, though, or the commentary does, that if you're collecting student loans, however, all of the loans in an account will be seen as grouped together. So you can't call, if you have 3 student loans in one account, you can't call separately on those 3 student loans. You have to treat them in the aggregate as one account. So that's the only exception, I would say, with the per debt guidelines in the new rule.
It's an interesting point, Lauren, that you raise, and I'd actually have to go back and look at the specific comments in the commentary. When they referred to the student loans, were they referring to, was it under the guise of the same institution, basically different semesters, or was it different types of loans? So if you're getting a Perkins, if you're getting a Stafford, but you have maybe some private loan from the school itself, are all of those consolidated for purposes of call caps?
That's a great question. So they don't get down into the nitty gritty, at least not that I've seen, into that that specifically, but they do say essentially if the collector would lump any of those loans together into one account, then you have to treat your call caps as one account. So, but they don't get into, okay, if you've got a Perkins and then you've got a direct, and they're under different accounts, you could call separately. They don't get into that nitty gritty. So I think it largely depends upon how a debt collector collecting student loans groups those loans together, or they don't.
Okay. Excellent. Good start to our conversation. A couple of questions that have come in so far. We'll use this as an opportunity to ask them and to remind everybody, if you have a question, type it into the Q&A box or the chat module. We'll try and get it asked and answered during our conversation today. First question, Rick, going back to the clock, you mentioned the ticking clock. Can that clock be adjusted based on the pending disclosure rules?
Well, you mean the proposed aspect that's going to come sometime in December 2020? If that's the question that's being asked, the model notice disclosures. Look, the CFPB, for its own reasoning, decided to split up its announcement. And to the extent that there will be a subsequent issuance of some guidelines through a second rule. Right now, the current rule is 1 year from the date of publication. That's already been passed. We know that this aspect of the rule will go into effect November 30th, 2021. Again, barring a couple, two big events, I think that will rise up given the new administration. This model disclosure, and with that, arguments about a statute of limitation notice, credit reporting notice, and the format of the model notice that's supposed to be part of what I'll call the December 2020 rule. They have not indicated whether it's going to be a 1 year implementation period. They could very well release the rule when they release it, and if it actually happens in December 2020, and say that it's going to go into effect at the same time as the previous release. So we're not guaranteed that the second rule is going to be 1 year afterwards, and probably for the sake of everybody involved, it would probably be good to try and coincide the implementation period instead of having a split implementation period. But because because one because one deals more with letters, one's going to be dealing more with communications and technology. It wouldn't be the worst thing in the world, but right now, we don't know what that second rule time frame would be.
Okay. Another question. I thought the rule is communication attempts, not calls. So calls, email, mail, text messages all count in that aggregate 7. Lauren, I see your head shaking no already.
So the 7 attempts is for phone call attempts specifically. However, I do caution that the commentary goes to great length to point out that even though this is applicable only to call attempts, that it is conceivable that if somebody is in compliance with the presumption, they could still be in violation of 1692D if their call attempts in conjunction with their email activity or their texting activity, that could still be seen as potential harassment because they look at the cumulative effect of the collector's activity. So even though it is just 7 call attempts, you still have to be careful that your other emailing and texting and other outreach efforts don't run afoul with the general prohibition of not doing anything that could be seen as harassment, abusive. And so you kind of you still have to look at your whole collection activity to make sure that you won't run afoul with 1692D. But the 7 and 7 rule is just for phone call attempts.
Right. I think that the initial thought was in the initial proposal way back when. I don't even know when that happened because it's been 7 years of constant rulemaking or proposed rulemaking. The thought was that emails, texting were going to be part of this rule in a more formal sense. And when they issued this rule, they're mentioned, they're sort of acknowledged, agencies are not dissuaded from using them, but they're not adopted in any formal sense saying email, texting is completely legal and you can do it in so many ways. There are some references to it. And so when they made this contact attempt, they expressly excluded both letters, texts, and calls from sort of what we'll call the safe harbor of that, the rebuttable presumption. And that's important. And Lauren points it out correctly. It is a rebuttable presumption. You can make contact attempts even under the 7 and 7. And let's use an example. You can call 7 times within 7 days. And it doesn't say that you have to do 1 per day. It doesn't say that at a certain interval between the times. But you could imagine if somebody wanted to make a phone call and not get an answer, and say dial the 7 times on a single day, a minute apart, you're going to get a plaintiff's lawyer that's going to sue and say that the presumption, the rebuttable presumption of legality has been thrown out because the intent was to harass and abuse the person by calling them back to back to back to back to back to back when you got no answer. So it is rebuttable, but it expressly excludes, for purposes of the presumption, text, emails, and letters, which is different than, and we'll probably talk about it a little bit later, places like Massachusetts, where contacts include all nature of contacts in the state of Massachusetts, which is a little bit different than this.
Nothing like confusion to make things easy to follow. At this point, I want to pause the discussion, and I'd like to invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay?
Hi there. Thanks, Mike, and all the panelists that make this discussion possible. As Mike mentioned, my name is McKay Bird, and I am the marketing director here at TCN. Many of you are probably maybe not familiar with who TCN is, but we provide cost-effective call center solutions for traditional contact centers, collection agencies, and as well as thousands of businesses around the world. TCN has continually stayed current with TCPA and the CFPB changes by introducing enhancements to our core platform. And one of these enhancements we introduced earlier this year called natural language compliance. This tool uses smart algorithms to build compliance rules naturally. And you simply just need to type in your rule into the compliance manager, and the natural language compliance engine will build an easy to understand compliance rule. And that's not all. Just because we are a platform and a software suite of tools, we also provide built-in data management services that eliminate data entry errors for sharing data between systems, as well as business intelligence with reporting dashboards, call recording with storage, smart IVRs with payment capability, speech analysis and transcription, and so much more. So regardless of size, location, or application, TCN can provide robust call center solutions for your call center and as well as collection agencies. And I invite each of you to go to tcn.com for more information. Thanks, Mike, for the opportunity.
Excellent. Well, thank you, McKay. And thanks again to TCN for sponsoring today's webinar. I really appreciate their continued support. Correct me if I'm wrong, and I'm sure there are a couple of you who are facing me right now who will have no problem doing so. But aren't there types of calls that don't count to the 7 and 7 limit?
Third party calls.
Okay. So those don't count.
Yeah, I mean,
Unless it depends.
the rule. Go ahead, Lauren.
I was going to say there are a handful of exceptions to the 7 and 7 rule. So, for example, the CFPB explains that if you are making a call to comply with some other law, that could be an exception to the 7 and 7. If you are placing a call that was directly related to active litigation involving that particular debt, that would be an exception. They also detail that if you're placing a call in response to the consumer's request, that would be an exception. But note that that request has to be, essentially you need the consumer's consent, and that consent must be given directly from or directly to the debt collector. And so if you have their consent, their direct consent, that won't count against you in the 7 calls. Also, this one was really interesting. If you're placing a call to convey information to the consumer that would provide them with an opportunity to avoid a demonstrably negative effect, and where time is of the essence, essentially that particular call might be accepted from the 7 rule. That one has a lot to unpack, and I'm kind of curious to hear what Rick and LaDonna's thoughts are. If you think that particular exception where you're placing a call because time is of the essence and you're trying to help the consumer avoid, for example, a late penalty or a missed payment or something like that, if you think that might be a potential landmine for us in the future. Just curious if you guys want to spend any time on that particular exception.
I wouldn't do it.
Right. I mean, when we talk about the exceptions, I mean, I guess that's a practical application aspect of it. If I was advising clients, I would be very cautious about talking to them about what exceptions to use, primarily because it's going to be your defense, right? To a certain degree, when you're gone to court, and like the bona fide error defense, where it suddenly becomes your burden to prove it, and it's a lot harder, or you don't want to be behind that 8 ball, particularly with a fee shifting statute, by being the one that has to prove something. So it's not guilty by reason of insanity. Yes, I killed them, but I was insane. The problem is you've already set up with I did something wrong and I'm going to be penalized for it, and now I got to prove why not, which is always the difficulty with the bona fide error defense. You're automatically going to court and saying, yeah, we did something wrong, but here's why it should be excused. When we go to the exceptions, unless there was something really crazy, and really the court one is probably the best example. You've already satisfied your 7 communications, or you've already spoken to somebody previously, and the court calls you up and says, the hearing that's going to happen tomorrow is not happening. Call your opposing counsel, or in this case, call the pro se, and confirm with them they're not showing up at the courthouse. It may have value in trying to reach out to them and communicating and saying, hey, this hearing's not going on tomorrow, don't show up, because otherwise they'd be heading down to the courthouse and you'd have some problems. So there'd be value there. But in a lot of other cases, if you're going to try and invoke such as an exception, you may be the one trying to defend it, which puts you at a difficult position.
Hey, Mr. Purr, we're going to put this on your credit on Friday. Just calling to let you know that.
Yeah, I mean, that suddenly comes into, what are you trying to do? Are you really trying to call them to prevent an adverse effect? Are you really trying to coerce them into calling you back or talking to you because of some engaging activity?
Have to be one or the other?
Well, if you get sued, you're going to try and defend on, I called for this reason. And how many people are going to buy it? Look, we can look at something as an example that I deal with this litigation all the time over the 1099 language on letters. We put in the 1099 language because we're going to disclose to the consumer that if they compromise their debt, the write-off is going to be a potentially taxable event. And if we don't tell them that, we're going to get sued. But the reality is you don't really have that obligation, and it really belongs to the client, not you, the collection agency. And many courts, or most courts, have found that the use of that language is used to coerce the consumer into paying the full amount of the debt and not dealing with the IRS. So we can have an explanation for why we're doing it, and it can sound very plausible. Problem is you're going to have to get a judge and jury to believe that. And why would you go through that if your choice is not to make the phone call at all?
Kind of reminds me of that saying, no good deed goes unpunished.
Exactly.
You might want to help the consumer out by saying, hey, I know you're going to miss your payment and the creditor is going to have a penalty. I want to help you avoid that. But there you go. That good deed might go punished. So keep that in mind for sure. Something else that was kind of interesting about that particular exception is they say that the negative effect must be completely outside of the collector's control. So if you are going to lean on that exception, like Rick is saying, be fully prepared to demonstrate and to prove that negative effect, you did not have any type of control over it, whether it occurred or didn't occur. Because if you do, then the exception, you won't be able to use the exception at all.
A couple other areas that don't count as calls, and we should start off by saying that leaving the limited content message is designated as an attempt to communicate. It's not designated as a communication, but for purposes of call contacts and this call limit, it is included in the attempts to communicate. So if you're leaving the limited content message, it counts. But things that count, it's like some of the weird intricacies, and if you look in the commentary about how they describe it. So I call LaDonna, I'm speaking with her, and in the middle of the call cuts out. Well, I've communicated with her, that counts. And it would be up to her to call back at that point.
And I'm not. You're a debt collector. I'm not calling you back.
But if I call LaDonna and I get a busy signal, not an attempt. If I call LaDonna and I get one of those crazy messages, the number you were trying to reach is out of service, or the call could not be connected as dialed, not an attempt. I call LaDonna and it rings, but no answer, an attempt. So I call LaDonna, but I really am calling Lauren's telephone number by accident, even because I don't know that it's not. I got the number from skip tracing. Technically, that doesn't count as an attempt, although you may not know that it's not an attempt until at some point in time in the future, you learn that you were calling the wrong number. But calling the wrong number doesn't count as an attempt. So there's a few things in there that may not seem clear on its face what is or isn't an attempt.
Rick, I'm so glad you kind of teased that out, because on the surface, this rule looks really simple, as LaDonna was saying, and it is. But when you get into the commentary and these different situations, does a call drop? If you call back right, if you call back right away, does that count? There's so much nuance. There's so many nuances with the commentary that it really is important to pay attention, to read thoroughly, and we're really going to have to train our collectors to, really well on these nuances in order for us to remain in compliance and to not be overly strict with our efforts. So it is a little bit complicated once you start to dive into the details.
Yeah, and we're going to have to rely on technology. We use so many dialing resources to help us, and are they going to be sophisticated enough to, pick up the sit tone or not bring you back false positives and such? But from an operations perspective, I think this is going to make us more leaner and smarter with our strategies when attempting to contact consumers, because really, I think a lot of places over dial as it is. What's the magic dial to get somebody to answer? Was calling somebody 7 times in a 7-day period, is that going to make me answer? No. Is it going to make me call you back? No. So it's just going to call for people evaluating their data and find out what's going to be the most effective.
Yeah, you bring up a good point about the technology, in the sense that it's per debt, right? So. Right. Let's say you're collecting a medical debt and a credit card debt, and you make an outbound call and the consumer doesn't answer. You can actually assign which account you want that attempt to go to. Do you want it to go to the medical debt, or do you want it to go to the credit card debt? So really thinking through our technology and figuring out, okay, how are we going to do that? How are we going to allow our collectors to assign that attempt to one particular debt? Might be a little bit complicated. So although we can rely on technology, I feel like it's going to be quite an endeavor to figure out how to actually program this to do it.
But as compliance officer, I'm not going to let you mingle the medical and the credit card.
Which kind of shows you, I suppose, that the Bureau was maybe not fully informed about collections in that sense, that it's not. That's not a realistic thing that we would do anyways. Yeah.
Right.
So, but you both raise a great point, which is the intersection of compliance and technology, and how this year that we have to implement these rules is going to go a long way in trying to figure out what you can possibly do in best practices to implement procedures and process. So it's going to be technology wise, if your computer systems, programming in, figuring out what's right for you. If it is, to avoid that 7 calls back to back to back to back, maybe it's going to be something that you're going to lock out calling an account so that it's only once per day. Or you're going to lock out that there must be 4 or 5 hours between a call. So if that call drops, your collector may not be able to, despite their best intent or whatever, to make that telephone call unless the consumer calls back in, because your technology is going to lock out the discretion of the collector from doing something that may cause some liability. Also, you're going to maybe change your scripts. I saw a comment in the Q&A from Deborah Siski, who raises a great point, which is maybe at the beginning of every telephone call, one of the first things you say after your mini Miranda is, if this call drops, do I have your permission to call you back? And getting express consent to return the call for just that situation. So your practices are going to slightly change, and it's going to take a little bit of time of figuring out what works best for each company and how to modify that to make sure that your collection agents are efficient, but at the same time getting themselves ready to comply with the law when it goes into effect. So those things are going to be interesting to see as we test it. And both of you who are hands-on right in your companies, whatever you start with January 1 in terms of what you think you're going to do, I'm willing to bet that by September or October of next year may be different after you've either technology capabilities or otherwise, or just even efficiency, are going to say, you know what, that just really doesn't work for us.
Okay, well, let me ask you a question, because before we started this today, I made mention I've seen you do like 6 of these and pretty much talking on the same subject. Do you feel more informed now than you did when the rules first came out? Because I think at 2:30 on October 30th, you were on a webinar, right?
I was on a webinar right away. Now we
so do you feel more informed now?
Crazy thing.
The more and more we read it, the more, and more importantly, the more and more I talk to really people in the field who are going to do this, it changes my mind a little bit, because the practicalities of how to implement this is just as important as the law. Companies are different sizes, they have different resources, they have different risk tolerances that affects what they plan to do. This calling someone and talking to them and not being able to speak to them again for 7-day aspect of it is something that people are going to play around with. Asking for permission to call people back, trying to encourage the consumer to call them back to avoid their outbound calls. How do you manipulate the system to try and make sure that you're not the one calling and that they're the ones calling back in? So I think everyone's going to play around with it. And I think that there's also a little bit of unintended consequences that the Bureau itself is dealing with. I know that for the limited content message, which is a little slightly off of the topic here, the whole concept of not using your name if it includes the word collection in it, they didn't anticipate, because I know that we've reached out to them about the problems with different words. All right. Performant recovery, that's not collection, right? It's not strictly collection, but if I'm a lawyer and I'm talking about the words recovery, I would be a little nervous about whether that constitutes the prohibition or not of you leaving your name that implies collection, even though recovery could be all sorts of different things. It could be medical, you're a medical provider. They didn't anticipate this type of blowback, and I think the Bureau is really grasping and trying to wrap its head around that aspect of it. So with some of these, as we're going along in the year, and I think another part of this proposal is they will issue advisory opinions. We could see some modifications and some changes to some of the practical aspects. But I think it's important for everyone who's listening, don't wait until September 1 of next year to try and implement this because you think that the Joe Biden administration is going to change the rules one way or the other, or you think that Congress is going to use the Congressional Review Act and throw something out. So you're going to wait until later on to see what happens. I think it's important that you get together with your compliance team, your lawyers, your operations folk, and try and start putting together a game plan of how to deal with call caps, how to deal with limited content message if you want to use it, and start testing it out. Maybe not in the public sphere, maybe it's just internally with your own people and calling them and seeing how it works. But I think there's going to be need for a lot of modification of what you're starting with and what you're going to end up with to see what works for you.
Okay, somebody brought up about the inconvenient time to contact a consumer. That really, to me, is not a change from what we currently do. You know, we don't reach out, we don't contact a consumer anytime that we know or should know that is inconvenient to the consumer. But what I thought was interesting on page, I think it's 601 of the document, it says if the consumer initiates communication with us from a place that they've already told us was, or a time that was inconvenient, that we can reach out to them through that same medium at that same time. Isn't that just risky? Did you follow me?
Yeah, you could do it one time. One time. Yeah, it is risky, and whether, like what Rick was saying, it's going to be up to us to figure out what our risk tolerance is as we implement these new rules. Maybe you just make it a policy straight across your organization that you wouldn't avail yourself of that. Or maybe you feel like you have the technology and your agents are properly trained to document that one exception or whatever, and you feel comfortable doing it. So I think it's really going to depend on your risk tolerance as an organization. But you're absolutely right. There is definitely risk associated with it.
I think it's just a big setup.
Well, I mean, it's a strict liability statute. It's a really tough situation when you're saying no matter what your best intentions are, if you break the rule, you're liable, and then you're going to be paying someone else's attorney's fees, which is really the kicker. It's not the statute as much as it is the fee shifting. So when you come up with procedures, my guess is that most companies are going to not want to deviate from them. So if they have a rule that says inconvenient time and place, and really place is a bigger one now that's been added in and trying to clarify that. And there's a big emphasis on location as well as just time, which I think is a subtle change that don't deviate from it. If you're told, I don't want to receive calls at 5 o'clock, between 5 and 8 every night, and you get a call at 6:30, I mean, I wouldn't even return the call at that period of time or mark it. I would just move on and never call them between 5 and 8. Talk to them if they call in, but don't use that as an invitation to reach out to them, because you're only going to get yourself in trouble, because there's going to be somebody somewhere that's going to decide 5 o'clock is good and take it out of the system or do something that's going to change that. And you run into a problem when that happens. Part of the communication caps, I think, that are in here, there's really a real drive by the CFPB in these regulations to give the consumer much more flexibility in describing how and when they want to be contacted. And that's not a bad thing, I don't think, for agencies, because I think that you guys also want to make sure you're doing things that aren't annoying the consumer, even if you legally can do it, because somebody who's annoyed tends not to pay, tends to be belligerent, and could lead to litigation. So if they, right now you have a cease and desist, you send a cease and desist in writing, and you have to cease and desist everything. Wouldn't it be easier, and it is, if someone is able to tell you, it's okay, send me letters, make phone calls, but don't call me before 5 o'clock on a weekday. You can just put it in your system, have it done, and now you have a reason to do it because it's codified that you can do it that way. You don't have somebody in compliance or in a lawyer telling you, well, if it's not a full cease and desist, you can just ignore it. Because then you end up with an annoyed consumer, which leads to potential lawsuits. So, there's benefits to both the consumer and the agency by having some of these restrictions, including the contact limits.
Hey, Rick, our good friend Larry Lasky asks, do you expect the courts are likely to treat these rebuttable presumptions as more of bright line rules? And does this rule actually mean more cases will need to go to summary judgment versus motion on the pleadings? Does this really differ from any current reality in terms of the courts? What do you think?
Well, I think that it's good. The summary judgment cases that we have across the country on frequency are all over the place. You got courts that are granting summary judgment because you called 30 times in 1 week and said that's fine because it was to different numbers and et cetera. And then you have courts that say, you called 6 times in a month. It's a fact question as to whether that was annoying and harassing. So there is an inconsistency. I think that you'll find some of those judges who may have been on the fence before, who may have called it a question of fact, may, using these rules, be more inclined to grant some more summary judgments because they have something in the background. But if you do something that's questionable, again, 7 calls in 1 day, let's assume 4 calls in 1 day that may be totally legal, but because of the time and placement, you're going to still get the same type of result. And I think that you're going to see plaintiffs pushing for that, which is to get over the summary judgment hump. Their goal is only to create a question of fact because they figure that if you're forced to go to trial, you'll settle before you go to trial. And so their whole goal is not to win the case on summary judgment, just not lose it.
Right.
And these rules, I think there is going to be litigation over it, undoubtedly, because they're going to do it. But I think you're going to find that with the rules in place, unless someone's going to be able to come forward and show really with the annoyance harassment that if you call within these parameters, you will tend to be safe, barring something that's just that you can look at and say is wrong. Or the example that you gave before, LaDonna did, which is I called you back the one time to tell you that the emergent event is going to be some credit reporting that's going to happen on your account. I think a judge is going to say, look, we'll let the jury decide whether that exception applies. As opposed to if you never made that phone call, you probably could have gotten summary judgment.
Yeah. I have a question. I saw this phrase pop up a couple of times. They say in the commentary, for example, for purposes of determining whether the presumption of violation has been rebutted, it is assumed that debt collectors intend the natural consequence of their actions. What the heck does that mean?
Thank you. What does that mean, Mike?
I'm going to ask. I think it should be one of you that are answering that question.
Yeah, I feel like that's going to be ripe for litigation. It is assumed that debt collectors intend the natural consequence of their actions. Well, I could argue all day the natural consequence of my action is to establish a relationship so that you pay your debt. Does that mean it's harassing? I don't know. I'm sure the consumer would say it is, but really, what does that mean? Rick, what do you think?
I think it's going to be. I'll say what I think the CFPB intended was to try and I don't know if they did anybody any favors, but was to say, if you call, the natural consequences is you're expecting somebody to answer and you're expecting to talk to somebody. If you're calling at 12 midnight the natural consequence is to wake somebody up. And that's what you're intending to do. And so I think what they're saying is you're putting it in context, not to provide anything more sinister or less sinister about the phone call if it within the context of when and how it's made. If you call 7 times in a row, take it for what it is. You called 7 times in a row. If you called 1 time and the call got disconnected and you called back, take it for what it is. But I don't know that they did a great job, and I'm sure it'll be tested out a little bit with some litigation. I don't think that anything in here ends litigation as we know it. I think there's a few more protections and a little bit more for the court to jump into, particularly on these discretionary items. But the bigger thing on saving us from litigation may be, to a certain extent, whatever notices come out in the second rule, which tends to be the bigger area of the just the blatant, I'll say frivolous litigation over collection notices, because it's missing a period here, or there's something here, or the argument that you're not identifying the creditor correctly, et cetera. Following a model collection notice may end up being a safer harbor than what we're talking about with these call limits.
That's scary.
There's an interesting question here. Since TCPA court case identified text message as a telephone call, is it likely that this definition will bleed into interpreting the FDCPA? And I guess in particular, these call cap attempt rules. How is the TCPA going to play with FDCPA going forward in context of these new rules, if anything? What do you guys think?
I don't think the TCPA is going to come into the FDCPA. I think they're going to continue to be cash cows for the predatory attorneys. And what we do, we're going to have to, when we're doing our strategies, we're going to look at the TCPA separately and the FDCPA, and then look at what's going to cause the least harm to the consumer.
I mean, there's different words that are used in each of the statutes and different purposes. So when we're talking about the FDCPA and communication that we're talking about here, we have attempts to communicate. Communicating being, conveying information through any medium, any information related to collection of a debt. So the FDCPA portion, a text message is included in terms of an attempt to communicate. It's just for the call caps, they expressly exclude communication via email and texting to fall within, I hate using the phrase safe harbor, but the presumption safe harbor that exists under this. So you don't have any more greater protection from texting. If you text, you're on your own in terms of what the CFPB has put out in the rule for purposes of the FDCPA. You could text 10 times in a row. It doesn't give you the presumption. You could text once every 7 days. Still doesn't give you the presumption of protection. Whereas in the TCPA, it refers to a call, meaning a specific action. And the whole arguments that people have made about texting and calling was it's not really calling the phone. And the courts have just concluded that technologically wise, the definition of call in the TCPA includes texting because it uses similar technology and similar bases for zipping it up into the cell and zipping it back down to your phone. So it's the same as a call for purposes of the TCPA. But I think that LaDon is right. I mean, they don't mix. And you're on notice, and they say in the commentary, you're on notice. You can use text and you can use emails under the FDCPA, but you're still subject to the same ambiguous language about collection activity that existed, under the 1978 version pre-rule.
Well, here's my strategy. My strategy is going to be to open up as many communication channels as I can to get the consumers to reach out to me. So my outbound reach, there'll be less risk there. So you can text me, you can email me, you can go to my website, you can do whatever. But see, that's going to cut down my outbound attempts. That's my strategy. Isn't it brilliant?
I think you're right, LaDonna. I think in this new environment we're in, we really need to think about how we got to think differently.
Yeah.
It's no longer just outbound calls. It's really figuring out how to get the consumers to you, how to enhance their experience when they're working with your agency, and really taking a customer service approach to your collections. I think that this rule makes it abundantly clear that this is the way. It's not even the wave of the future. It's now.
Yeah.
Yeah.
More chats.
Yeah.
I mean, one of the things that is in the commentary, and it's covered throughout the rule, and for anyone who had the good fortune of communicating with the CFPB during the implementation of the rule, is that they recognize that obtaining right party contacts leads to less communication, because once you're able to find the right person, your communication becomes less frequent, because you're either resolving the issue with them, you're getting them into a payment plan, you're having some conversation, or alternatively, you're finding that they're not the person, they're not going to pay the debt, they're not really somebody who you need to pursue, and the communication is going to cease. And so a lot of these rules, and what it talks about in the commentary, is that these rules are designed to increase right party contacts that would lead to less frequent communications, which means less disturbance to the consumer. And then everybody's in a win-win situation. And I think they're right. I think that that's what we've communicated as an industry to them, that happens. And so, Donna and Lauren, when you talk about having more inbound calls, I mean, that's the goal. If you could eliminate all of your outbound calls, not to put people out of work or anything, but your efficiency and your collecting and your company's profit margins would go up, because you're not spending all that time pursuing circumstances that are going to be unsuccessful. And if you could concentrate solely on having enough inbound calls to keep your companies afloat, that would be, an ideal circumstance, and that would be beneficial to the consumer as well. So, that's a way that the industry and consumers go hand in hand. And if you can do that, and with these rules, I think you're right. That's the goal to move towards.
I think we can do it.
We've only got a couple of minutes left, and there's a question or two here in the queue that we haven't gotten to yet. And one wanted to clarify the 7 and 7 limit. Is it per debt or per person per debt? For example, not 7 and 10s for the husband and 7 for the wife, to discuss the same debt which they're both jointly liable for.
It depends. Great question.
Spoken like a true lawyer.
Yeah.
We'll look at the definition here, exactly what it says.
You see, if I got to look the definition up, I'm going to say if it's the same debt, I'm sticking with the 7 rule.
It says if the debt collector places a telephone call to a particular person in connection with the collection of a particular debt. So it's both. It's a person and a debt. So the question of the joint, if a if a debt is jointly held by spouses, you could call each one of them 7 times. But this gets us back to what we started off with, which is, how are you going to have to change your systems for documenting, what the purpose of these calls are being made to? If you have 3 accounts that belong to a particular person in different treatment times, for example, if it's medical debt, so they're recognized as 3 separate debts, and you want to call, and you in the past used to merge your accounts and put it under one number, even though you kept 3 separate accounts. Well, Now what you're going to have to do is specifically identify, I called for debt A to this person at this time. I called for debt B to this person at this time. So you're going to have to keep track of your 7 attempts per account, per person. And if you have joint debts, you're going to have to make sure you keep control of that, and you're going to have those records. It's going to be a change. But the hopeful part about it is by keeping track of those records, if something happens, you'll be able to go back to it and say, here's our logs. Boom, boom, boom. Give us summary judgment.
All right, we have 3 minutes left. Actually, we have 2 minutes left, but there are 3 of you. So I'm going to give each of you 1 minute. We're going to go a minute over to offer any summary, parting words of wisdom, any other words of advice, what to do with your Thanksgiving leftovers. However you want to spend that minute, it will be up to you. Lauren, we'll let you go first.
Okay. I would encourage everybody to thoroughly read the rules and the commentary, and to assemble a cross-functional team within your agency to figure out how you're going to operationalize these rules. Don't be too hasty in implementing things right out of the gate, because things might change and things might further evolve as we gain a deeper understanding of these new rules. So I really encourage everybody to take their time in the sense of be a student and take out your highlighters and your pens and really just go through there and start to build a project plan on how you're going to operationalize compliance, and be very thoughtful about how you're going to implement it, possibly implement it in phases. And that way you're fully done when it comes November 30th of 2021. So that would be my parting words to everybody, is to take their time and to fully get all stakeholders involved, and to build a cross-functional team to figure out how you're going to adapt it for your organization.
Excellent. Thank you, Lauren. LaDonna?
Yes, cross-functional team, operations and compliance have to work together. Now you have to get ops involved in this from the ground up, so they'll know what to expect. Get your vendors involved, ask your vendors what are they planning to do to help you be compliant, and don't sweat it, really. This is going to be a good thing, I believe, because it's going to cause us to be more efficient with our calls and not make the unnecessary calls and not have that risk. So I'm glad they finally put some fences around calling.
Excellent. Thank you. Rick?
I think overall, the proposed rule in all of its facets, while there are a couple new hurdles that agencies are going to have to face, have been a positive for the industry. I think it strikes an appropriate balance. We know that at the end of the day, government continuing to push and push and push in the form of regulation. With the change of administrations, I know that we're going to see some more of those things. So hopefully not as drastic as it could have been. Nevertheless, you need to embrace these changes. And as Lauren and LaDonna said, get together with your teams of people, get together with your attorneys, get together with compliance to make sure that you use the 1 year that you have to its fullest. You don't want to be caught flat-footed on November 30th, 2021, trying to implement some of these things, because it's going to take time and it's going to take some modification and it's going to take effort. Fortunately, you have great resources throughout the industry that can help with that, but don't be afraid of it and embrace it.
All right. Well, LaDonna, Lauren, Rick, thank you so much on behalf of everybody watching. Thank you so much for your time and your willingness to share today. I really appreciate your participation.
Thank you.
Thanks, Mike.
And everybody else, thank you for watching and listening. Thanks for your questions. Thanks one last time to TCN for sponsoring this webinar. Please go to www.tcn.com to learn more about the company. We'll be back on Wednesday. We're talking about electronic communications, or email and text messaging. So if you haven't signed up for that webinar, go to accountsrecovery.net and sign up now. And we'll see everybody back on Wednesday for our next conversation, our next discussion in this important series. Until then, everybody, thank you very much. Stay safe, and we'll talk to everybody soon. Take care.
Bye.